is a hugely important decision, in my view, of the European Court of Human Rights. It's a decision by the fourth section, not the Grand Chamber. And so there is the possibility that it will be reviewed by the Grand Chamber if the UK government asks the European Court to refer it up and for the Grand Chamber to review it. Even if the government asks for that to happen, it doesn't mean that it will happen, but there is the possibility. I spoke to Nicola Burgess of JCWI earlier today to ask her what the position was, and she said that the government was considering its position, so we don't know whether this is going to go further or not. But this is stellar work by JCWI and Nicola Burgess. I'll just very quickly run you through the facts. It was an Article 8 claim, a deportation case, an Article 8 claim that deportation would be disproportionate. And the application before the European Court, after fully exhausting domestic remedies, was that the Article 8 claim in substance was wrongly determined, and asking the European Court to make a finding that deportation would be a breach of Article 8. And there was also a complaint that Article 8, either taken alone or read with Article 13, meant that domestic law was inconsistent with obligations under the European Convention, because domestic law had prevented the relevant decision makers from conducting a detailed proportionality assessment. I think specifically Section 117B and the relevant immigration rules, associated immigration rules. Next slide, please. So the facts were the applicant, a Nigerian national, born in 1963, 3 children with a Nigerian partner, D, B, and C. D, British throughout, B and C also registered as British. D had a congenital heart defect that would have required further surgery, and that was one aspect of the case. Nigerian partner, they were married in 1995, relationship broke down, but then they reunited eventually in the UK and recommenced their relationship, and the children were born subsequently in the UK. Next slide, please. In February 2005, the applicant was convicted of a sentence, of an offence of obtaining a money transfer by deception, sentenced to unpaid work in order to pay a fine. November 2009, more serious offending in relation to falsification of some 30 applications for leave to remain, and the partner was also involved in this. So both were convicted, partner to 18 months imprisonment, the applicant to 5 years and 6 months imprisonment. So he was on the highest threshold under the current regime, immigration rules and Section 117B, a sentence of over 4 years. The custodial sentence ended on the 26th of October 2012. He remained in immigration detention until the 6th of November 2012. Next slide, please. Deportation order was made on the 2nd of June 2014. The Secretary of State considered that deportation was appropriate. It was, of course, squarely within the automatic deportation provisions, and there was an assessment of the Article 8 claim, and unsurprisingly, the Secretary of State found that deportation was appropriate. This was obviously a sentence beyond 4 years, and therefore, certainly for the Secretary of State, it would have taken something spectacular for a first instance decision not to deport. Next slide, please. I think we'll skip over some of this because the detailed background is probably not necessary. Anybody that is interested can read through these slides later. We can provide the slides, but we're running short on time, so I'll skip through some of the background. The appeal proceedings we can have a quick look at. Feb 2015, FTT dismissed the appeal. Jan 2016, the upper tribunal allowed the appeal, but then it was to be reheard by the upper tribunal. Next slide, please. And the upper tribunal in October 2016 dismissed the appeal. There was a medical report from a consultant pediatric cardiologist. D had already undergone 3 open heart operations and would require further open heart surgery in order to replace a tube between the right ventricle and the lung arteries. So in the next 3 to 4 years, and the necessary surgery would not be available in Nigeria. There was apparently an OASIS assessment or probation service assessment that there was no risk of reoffending, but the representatives were not able to produce a copy of the report. But at the very least, it looks like this was a low risk of reoffending case. Next slide, please. There was family back in Nigeria that the family, the applicant and his family could return to. The decision of the upper tribunal was that D was a British citizen and a minor and could not be expected to leave the UK. It would be unduly harsh to split up the siblings, and the wife's appeal with the lower sentence was allowed because of the impact on the children. But the appeal of the applicant was dismissed, the upper tribunal concluding that there are no very compelling circumstances over and above those described at paragraphs 399 and 399A of the immigration rules. It is pertinent to note that the tribunal found that the wife needs him, needs the applicant, and the boys need him. The Court of Appeal refused permission to appeal. The applicant was deported on the 27th of February 2018, but his application to the European Court clearly continued. Next slide, please. So in the judgment, the European Court goes through the domestic legislation and the domestic legal landscape in terms of case law in some detail, setting out the statutory background, the immigration rules, and then moving on to the case law. The case law begins at paragraph 39, and reference is made in some detail with extracts being set out to MF Nigeria, NA Pakistan, and then Hisham Ali in some detail, and a brief reference to Agyarko. In relation to Hisham Ali, this is where I think that this case becomes very interesting. Hisham Ali was a majority judgment with Lord Kerr dissenting. And the case of the applicant was essentially that Lord Kerr was right, and that if one were to apply the overall balancing factor of Article 8 outside the rules, in the context of a failure to meet the rules and a failure to meet Section 117C, then that would be contrary to the requirements of Article 8 to just carry out an overall balancing exercise without a prior hurdle. And the judges quoted extensively from the judgments in Hisham Ali, and the passage that was problematic from the point of view of the applicant and from the point of view of Lord Kerr is this. If you just bear with me, I'll find it. It's paragraph 50 of Hisham Ali. The critical issue for the tribunal will generally be whether, giving due weight to the strength of the public interest in the deportation of the offender in the case before it, the Article 8 claim is sufficiently strong to outweigh it. In general, only a claim which is very strong indeed, very compelling, as it was put in MF Nigeria, will succeed. And that really is the crux of the case as put by the applicant, and the point that was troubling Lord Kerr. Is there a gloss to be put on the assessment carried out under Article 8 if you cannot meet the requirements of the rules in Section 117C? The majority thought that there was, and that gloss was that there needed to be a very strong claim, very compelling, very strong indeed, exceptional circumstances. There's different ways that the test is expressed, but the point is the same. If you don't meet the requirements of the rules, it's going to be very difficult to succeed in the balancing exercise outside of the rules. albeit all of the factors that need to be taken into account pursuant to European Court of Human Rights case law, Strasbourg case law, must be taken into account. And this was, I think there might be, if we then go on to Lord Kerr's dissent on this, yeah, that's a paragraph 49 of the Unuane judgment. His view is very different. And it's worth reading this paragraph in full. Many who fall outside the categories set out in the rules enjoy a full family or private life in every sense. The significance of that inescapable truth is that under the 2012 immigration rules, anyone who does not come within any of the specified categories and who is liable to deportation as a result of their status as a foreign criminal must demonstrate exceptional circumstances in order to outweigh the statutorily imposed public interest in their deportation. That requirement runs directly counter to a proper assessment of whether an interference with the right to respect for family or private life on the part of those who do not come within one of the exemptions is justified. Next slide, please. So paragraph 56, we have the court's judgment on the merits. First of all, in relation to this issue as between the majority judgments in Hisham Ali and the approach generally taken that once you cannot meet the rules and you cannot meet section 117C, you have to show a very strong claim indeed, very compelling circumstances in order to succeed. And Lord Kerr's approach that one has to just carry out a neutral balancing exercise in which, of course, the public interest in deportation carries great weight, but one doesn't put a gloss on that by requiring a very strong claim indeed because you cannot meet the rules. In respect of that issue, the court doesn't make a clear finding in favor of the applicant, but when one looks at the paragraphs of the judgment, paragraphs 56 to 60, it's clear that the court is leaning towards the approach of Lord Kerr. And what the court says is that it cites from the minority judgment of Lord Kerr and says at paragraph 59, the applicant relied on the dissenting opinion of Lord Kerr in Hisham Ali, in which he made it clear that the convention did not permit a national policy which limited or dictated the weight to be given to the bulletive factors in the Article 8 balancing exercise. In Lord Kerr's view, the quest to strike the appropriate balance should not be encumbered by preemptive considerations of exceptionality. That was the way that the argument was put. And the court, next slide please, set out all of the criteria. So at paragraph 72, we have the bulletive criteria set out, which are well known, but worth revisiting because under an Article 8 assessment outside the rules, these are the Strasbourg criteria that would apply. And then at 73 sets out the additional criteria from Unuane. Next slide, please. And states very clearly at paragraph 74, all the above factors should be taken into account in all cases concerning settled migrants who are to be expelled and or excluded following a criminal conviction. It then, next slide please, at paragraphs 75, 76 and 77 makes it clear that the court will not readily interfere with a domestic assessment of an Article 8 claim, particularly because of the margin of appreciation. But it goes on to say that the exception to this is where there are strong reasons for doing so. It then summarizes again the complaints made by the applicant, 2 distinct complaints. Due to the requirements of paragraphs 398 and 399 of the immigration rules, the upper tribunal was not able to conduct a thorough assessment of the proportionality of his deportation. That's the argument, that it was prevented because it applied this very compelling, very strong test pursuant to the majority decision in Hisham Ali. And secondly, that his deportation would disproportionately interfere with his rights, the argument on the merits. Again, paragraph 76, the court emphasizes that the only exception to reconsidering a case is where there are shown to be strong reasons for doing so. And then from paragraph 77 onwards, next slide, please. It carries out its own assessment of the issues. Now, it curiously only deals with the immigration rules, so it doesn't deal with, this begins at 78, it doesn't deal with the applicability of section 117C, which is obviously a provision flowing from statute and therefore slightly different and perhaps more problematic for the court to deal with. So it confines itself to dealing with the immigration rules. And at paragraph 80 says this: in the present case, the applicant argues that the tribunal was precluded by the immigration rules from conducting such an assessment, and that the tribunal's only discretion outside the rules would be to consider whether there existed exceptional circumstances or, following the 2014 amendment, very compelling circumstances. As Lord Kerr observed, such a requirement would appear to run directly counter to a proper assessment of whether an interference with the right to respect for family or private life on the part of those who do not come within one of the exemptions is justified. So that seems to be a very clear endorsement of Lord Kerr's minority judgment in Hisham Ali. It then goes on at 81 and 82 to make reference to passages from Hisham Ali and Agyarko and MF Nigeria and NA Pakistan. So covers a lot of judgments and the majority judgments in Hisham Ali that talk about the need to take account of all the factors referred to in the Strasbourg jurisprudence. What it doesn't refer to is those passages in the cases which say that there is a very compelling test or very strong case indeed test that needs to be satisfied if you can't meet the requirements of the rules. And then it concludes at paragraph 83, in light of the foregoing, so I take that to mean in light of the clear statements by the Court of Appeal and the Supreme Court that all of the Strasbourg jurisprudence and the factors identified by Strasbourg must be taken into account in a freestanding Article 8 assessment. In light of the foregoing, the court does not consider that the immigration rules necessarily preclude the domestic courts and tribunals from employing the abortive criteria for the purpose of assessing whether an expulsion measure was necessary and proportionate. And my view is that what the court is saying, without saying it, is that the approach of the majority in Hisham Ali is potentially in breach of Article 8 obligations, and the approach of Lord Kerr is the right approach, and that means that you take into account all of the factors that you're required to take into account pursuant to Strasbourg jurisprudence. And the cases are all consistent that all those factors do need to be taken into account, but you don't add the gloss that there has to be a very strong claim indeed or very compelling reasons, because you can't meet the specific tests set out in the immigration rules. Of course, there is still weight and significant weight to be placed on the public interest side of the scales because of the offending, but there isn't an additional barrier because you can't meet the immigration rules. It then, from paragraphs 84 onwards, goes on to consider the application of these principles to the case before it. And in doing that, it clearly adopts an approach that is consistent with Lord Kerr's minority judgment. And again, reinforcing, I think, that the flavour of this judgment, that Lord Kerr's judgment is the right approach and the majority judgment in Hisham Ali is the wrong approach. It also makes reference at 87 to the fact that when one is considering the balancing exercise, one is looking not just to the length of the sentence, but one is also looking at the nature and circumstances of the particular criminal offence or offences committed by the applicant in question and their impact on society as a whole. And at 87, it goes on to say that the court of Strasbourg has consistently treated crimes of violence and drug-related offences as being at the most serious end of the criminal spectrum. So this is, again, another gloss on the domestic approach, which is focused on length of sentence as being the indicator of the seriousness of criminality. There is some, I think in the cases we've covered today, there is some scope for looking at the nature of the offence and the harm caused. But generally speaking, one is simply looking at the length of sentence, and that's certainly the way that the immigration rules and the statutory scheme works. But here you've again got an examination from Strasbourg as to the nature of the offence, not just the sentence. And then you've got a conclusion, which is based solely on the impact upon the best interests of the children. So one doesn't even have to get into the nature of the offence and the risk of reoffending. There is a balance reached here. Sorry, I should say 88, again, reinforcing the Lord Kerr point again, that the court says that the upper tribunal dismissed the appeal on the sole basis there were no very compelling circumstances over and above those which had applied in respect of his partner, applying that additional test once you can't meet the rules. And the court says, 89, in the court's view, this conclusion is not reconcilable with Article 8 of the Convention. And then it concludes by saying that in light of the impact on the best interests of the children, the seriousness of the particular offences committed by the applicant was not of a nature or degree capable of outweighing the best interests of the children so as to justify his expulsion. That's it for that case. I think a very interesting case, and it will be very interesting to see whether this has any impact and what sort of impact it has on domestic case law. And I'm sure that practitioners will be using this judgment when they are next in court with respect to a deportation case. Because if my analysis is right, potentially one can see that all deportation decisions thus far carried out in accordance with the approach advocated by the majority in Hisham Ali need to be reconsidered, because that additional gloss of requiring a very compelling case changes the balance. And if one removes that and adopts the approach that Strasbourg has adopted in Unuane, the outcome might well be very different. That's it for me on Unuane.